CPS has the power to remove children from families when that worker concludes that there is an immediate danger to the health or welfare of that child, and there is not time consistent to come up with another plan. Typically, those removal cases or conservatorship cases come about with children basically between birth and age 2. The most common causes of removal are, number 1, unexplained physical injuries to very young children, to nonverbal children. So stop and think about that for a minute. Baby falls off a changing table. You take the baby to the local hospital. In the large metropolitan areas, they have doctors who've taken a seminar on child abuse and believe themselves child abuse experts. That doctor looks at the child and says, "Oh my goodness, that injury could not have happened in the absence of intentional physical force. We don't believe your story that your child rolled off the changing table." So that's a very common scenario, or the scenario where the child comes in with fractures. Newborns have bones that are different from adults. Fractures are easily detectable in many situations. You find yourself in that situation battling against not only Child Protective Services, but a large medical institution and doctors. You're not only having to state your case against Child Protective Services, but recall that CPS is basing their findings on something that a medical doctor has told them. So it's very unlikely that Child Protective Services is going to go against the recommendation of that doctor when you have a young child with concerning injuries, fractures, hematomas, different things like that can happen as a result of accidental or non-accidental trauma. But remember this, in these matters, when Child Protective Services has a young nonverbal victim, they're always going to err on the side of the utmost caution. Another common scenario is where there is drug abuse ongoing in the home. Now, it's time to have this conversation. If you're using drugs, you have to get off of drugs and you have to stay off of drugs. That doesn't include marijuana, but if you're on the hard stuff, if you're on cocaine, heroin, fentanyl, any of those drugs that we typically see at this time, those children are going to be removed from your care and you're going to have to work a program. So, when CPS removes a child from the care of a parent, it launches into action a huge court process. Now, Child Protective Services has up to a year to figure out what they're going to do with that child, what they're going to do with your family. Here's the options. Hopefully, you're going to work the recommended services that CPS is providing to you, and CPS is going to agree to return your children to your primary physical care. Or another option is that a family member, a grandma, grandpa, aunt, uncle, some other person is going to be identified as a full-time permanent conservatorship placement for your child. Finally, and most troubling, are those situations where Child Protective Services has no alternative but to seek termination of the parent-child relationship. Why? Why do they do this? They seek termination of the parent-child relationship to make that child, your child, available for adoption by a non-related individual. So here's what I tell my clients in Child Protective Services conservatorship cases. Number one, it's going to be a long, drawn-out battle. Number two, it's going to be costly. And number three, you've got to go into this process with your plan A, plan B, and plan C. You want to give CPS, you want to give the judge hearing your case as many options as possible.